and we don't have anybody in the audience. One lady, if she wants to stand up and say who she is, we'd love that. And there's no use taking roll call because there's only 3 of us here, and we hope we got a bunch on the line. So that would make us have
take roll call so we know who's on the line. You know?
Okay.
I'll do the roll call.
Okay.
This is Kellen. You ready? Sheridan is here. Gerald Geist.
Here.
Clinton Glenn. Here. Ellen Lancaster. Sheridan Little. Mike Purcell.
Here.
Here. Larry Suker. Rod Wagner. Here. And Bill Yankee.
Here.
We
Have a quorum.
Good, because we're not going to do anything.
Yep.
What?
We'll eat one today.
Well, I know that, but anyway. Okay. We're ready.
So, Mr. Chairman, first item on the agenda is just a legislative update. And so I'll just, I know with regards to the commission, I was providing legislative updates during the session in terms of where the various bills were going. But the first one is the omnibus water bill planning, all of our level 1 and level 2 projects. And so what I would say with regards to both omnibus bills is the program, I think, enjoys broad support from the legislature, and it's reflected by the votes. So House Bill 81, third and final reading, passed the House 56-0 with 4 excused. And then as it headed on to the Senate, ultimately it passed the Senate on a 30-0 vote. And so if you follow any legislation, getting those kinds of supports on a bill is really outstanding. So, and I think that kind of is reflective of the process and certainly the work that the commission puts into it, as well as the staff. I'll give a little credit to Katie and Jody and Jason as they bring these.
A lot of credit to that.
Absolutely. And they make me look good too. Really the same thing happened on the water bill, the construction bill. Its passage came, ultimately, this is third and final reading in the Senate was 30-0. I'm reading this correctly. And then on the House side, 55-2 with 3 excused. And those 2 votes are probably worth mentioning. On the construction bill, the one significant amendment that happened was for the weather modification program in the Wind River Mountains. And it was proposed by staff and then ultimately the commission that we would fund that program on a 50-50 basis with other funding partners. And that equated to, I believe, a $230,000 appropriation for actual operations. Senator Hicks and others questioned whether that percentage was too high. And ultimately, before the bill went to the Senate Ag Committee, Senator Hicks and I discussed funding levels from other states, and kind of the origin of this amendment was that Colorado puts in $175,000 into their weather mod program. They have the benefit of having lots of ski areas and irrigation districts and entities in their Colorado River drainage, and so they get a large contribution of funds from those folks. And so as we talked, what we ultimately decided was to submit an amendment that reduced the appropriation for the Wind River program down to $175,000. So Wyoming puts in the same amount of money as the state of Colorado, and Utah is actually slightly less than that. So I think that was a fair compromise. And ultimately, that amendment was passed and it came through the Senate. So overall, both bills had very little controversy. I should mention that the 2 no votes in the House were related to weather mod, and there was a discussion that using silver iodide and spraying that into the environment or putting it in the environment, that it's a toxic substance and we should not be doing that. And so there was, I think, a second reading amendment proposed to eliminate the weather mod programs. That failed. And then ultimately on that third reading vote, those 2 members of the House voted no. And that was really, I think, the most controversy for both of those bills. And questions? So, Mr. Chairman, the next bill, Senate File 69, was a bill. Ultimately, it did not pass, but it was a bill that was directed at the Water Development Commission that basically said that when a sponsor, a qualified sponsor, so we're talking generally about governmental entities, irrigation districts, conservancy districts, conservation districts, when an application is brought by a qualified entity for a project that is not owned by that entity, that the commission before consider, or the commission had to hold a hearing, well, hearing's the wrong word, basically give that sponsor an opportunity to present to the commission what the public benefits might be with regards to that particular project. And I know that's an issue that's been in front of the commission. In your notebooks under tab L, I did provide the most recent Attorney General's opinion on this topic, December 12, 2017. And so, Bill, you're not familiar with that opinion. But it really got to back to this question of, can the commission fund privately owned projects? Can they fund projects that are really private in nature? And the one, I go to the short answer on page 2, the last sentence, it says, therefore, the commission may not fund water projects that primarily benefit private entities without exchange of adequate consideration. And so I point that out because even though the bill died, you will in the future receive applications from qualified sponsors that are for private projects. And I think it behooves the commission to provide to those sponsors an opportunity to explain to you what those public considerations might be. What are the adequate considerations that are being offered? Can it be fish passage? Can it be increasing the assessed value of a county? I mean, all of those things could be considered. And I think ultimately then it's up to the commission to make a determination, is this investment of public funds of an amount suitable that we're going to get in exchange adequate consideration from the private entity? And that can be any number of factors, but I think it is appropriate that you certainly consider those applications. I do believe very strongly this program was intended to benefit public entities and their public facilities. But in this case, if there is adequate public consideration, you may want to move those projects forward for funding. So it's, even though this bill died, Senate File 69, this issue has not gone away. And again, that's my advice to you going forward. Questions?
Yes. Gary, I'm going to offer an example to see if this is correct. Let's say the city of Cheyenne wanted to use the program to provide additional wells to Frontier Refinery. Is that something like that? Would that be within the parameters of this legislation? That's what they're talking about.
Yeah.
No perceived benefit, particularly to the city of Cheyenne? They're doing it solely to pass through our funds to a private entity.
So, Mr. Chairman, if that was the intent solely to benefit a private entity, I would suggest that that is a project that should not be funded. But you could then argue in that particular scenario that if Frontier Refinery has access to groundwater, that it reduces the demand on the city of Cheyenne's system, and thereby you avoid the need to develop additional water resources for the city. So that's, I mean, all of those kinds of arguments can be made in terms of what are adequate considerations on the public side of these projects. But that certainly, Cheyenne could look at that type of project in that vein and say, well, we don't have to build, we don't have to drill another well of our own in a well field. We don't have to develop the Belvoir at this time if we take a large industrial user, say, off or reduce their demand on our water system. It could get very complicated.
So do you think that we have to define enough benefits to offset the grant? Is that what the business we're in?
Mr. Chairman, I think it is good policy, but this would be up to the commission, that you feel that the public benefits that are being offered from this private project do equal or offset the investment of public dollars. But that's an opinion that's not shared by all. But I think to kind of look at the Constitution that says we can't use state funds to benefit private entities, if you can show that we are benefiting a private entity, but at the same time we're getting this amount of dollars of public benefit, in essence, it's a contractual argument that's being made. And so WYDOT enters into contracts all the time with private contractors. The public benefits that they get is a brand new section of road or interstate. That's the public benefit. It's a contract.
That's direct construction contract.
Mm-hmm. But it is that same concept that led Daniel Solich, who was the main drafter of this opinion, that in a contract scenario, that is exactly what you're considering. You're going to give public dollars to a private entity, ultimately, and you have to measure what are the public benefits that come back to the state, that accrue to the public as a result of this transaction.
But the dollars do have to flow through the sponsor.
Yes, they do.
Jason, would you make a note that in our August meeting when we review criteria, typically we review the criteria in August at the August meeting, that we talk about this and see how we could develop an addendum to the criteria as to how we would take this on?
Mr. Chairman, I'll offer one example, at least recently with water development, where public funds came through water development to private individuals, and that's Pavilion, where water development had managed contracts to install cisterns for private individuals that were having water quality issues. And in each of those private individuals has a contract with water development. And the public benefit that was offered at that time was long-term access to their private wells for sampling of groundwater for DEQ purposes, as we tried to further understand the groundwater contamination in and around Pavilion. So there, again, that was strictly a contract relationship. They got a cistern paid for by the state of Wyoming. In return, they offered this long-term access for sampling purposes.
Yeah, but that wasn't
tax.
yeah, but that wasn't water development funds. That was general funds that were appropriated, and they designated us to handle it.
Chairman, that's correct. But that contractual question was dealt with at water development by the Attorney General's office and water development in terms of putting those contracts in place.
Those were general funds.
Those were general fund money in to do the cisterns. They weren't water development money.
My recollection is it was water development funds, but yeah.
There was an amendment bring general fund money over and we were administered to handle it. Any other? Can you hear me? Are we done with that one?
Mr. Chairman, I'm done for now. Still confused, but done.
Okay.
So, Mr. Chairman, then the next group of bills, I will hand off to the state engineer.
Good morning, Mr. Chairman, members of the commission, Senator Hicks. I've got about 5 bills to discuss in addition to our following both the construction and planning bills every year and other things that Harry deals with. We also follow those that tend to be more directed at Title 41 that invoke the state engineer's office. So the first bill, and I'm going to go through the House bills in order and then the Senate files in order. The first one, House Bill 18. And Katie, I don't know if they have copies of the bills or not. You can look them up on the LSO website. This was a bill, not really a water bill. It was more directed at administration of that board. And it was to increase the employment authority of the board itself so that they could set the terms of employment of that position. The issue with the bill, I think, was that that position is a state position and rolls up under our budget. It is classified along with other board directors in the state as far as pay and duties and things like that. The turning over a position strictly to the board and the members of the board are not state employees. So what we have is a position essentially supervised through the state engineer's office, even though they work even though they work and report to and serve that board. It raised enough questions as to whether or not that board could be given those additional authorities that this particular bill didn't even really get a motion in the House committee. One of the things, 2 of the board members, I believe, of that board actually came and spoke because one of the problems, I think, with the bill was the board itself wasn't behind it. There was a member of the board that had sponsored it, but the whole board was not necessarily had given it all a thumbs up. So in essence, that kind of, anyway, that bill didn't move out of House committee. The second bill.
Question, Mr. Chairman.
Yes.
Yeah. Is that system working on the well driller's licensure?
Mr. Chairman, I think it is. That I tell you, the board struggles in a couple of areas. Number one, the person in that position back during the session has since resigned to go back to work for the feds and make more money. So they've had about 3 directors in 4 years. And so they struggle a little bit. What the board really does is make sure we license our well drillers and pump installers, and this board person spends time out inspecting if they get called, and they can hire inspectors to go out if there's a complaint against a driller. So yeah, I think it has tightened some things up. Boards of their nature, and this one is evolving. It's only been in existence for really 8 or 10 years. So it's still moving forward. It is self-funded, by the way. This board gets $50 off of every well application that comes into our office for which a licensed well driller must be used. That is their funding stream. They don't get general fund money. They also get a little bit from renewals and exam fees and stuff like that. But primarily it comes off the permitting side.
Thank you.
Thank you,
More discussion?
Commissioner Purcell. Mr. Chairman, the next bill I'll talk about, House Bill 47, Senate Confirmation of Water Compact Commissioners. This was a bill that sought to add Senate confirmation as a requirement for appointment of commissioners representing Wyoming on various interstate compacts. Right now, we have me serving, representing Wyoming on the Upper Colorado, the Yellowstone, the Bear. We have 2 other commissioners on the Bear, Adrian Hunolt and Tim Teichert. and we have alternate commissioners on the Upper Colorado. This would, typically, these have been governor appointees. They are essentially at the pleasure of, if the governor wants to remove you as a commissioner, he can do that. This would have required Senate confirmation of those appointments. This one came up in House Ag, and after debate on both sides, it did not get out of that committee 8-1. But that was the nature of the bill. It was a additional, I don't know if you want to call it checks and balances or an additional movement to confirm those commissioners. Mr. Chairman, the next one that we're going to go to is Senate File 39, Legislative Approval of Water Compact Amendments. I'll read the language out of the bill that is at issue here, or the main language in the bill. It was not a long bill. Any action other than a judicial decision that amends or otherwise adds or removes any requirement or stipulation to a negotiated interstate water compact is not binding or obligatory upon the state unless the action is approved or ratified by the legislature of Wyoming. I think, and this bill also did not, in fact, the sponsor, Senator Hicks, pulled it back in committee, but I think it was because if you read each of those compacts, there's language that's almost always at the end that says nothing in, I'm going to paraphrase here, nothing in this compact can be changed without the approval of the legislature of any signatory state and Congress. And so, in essence, the language that, or the intent of this bill, in my view, we already have. We already have the, I can't change a period in any of our compacts without that legislative approval, and nor can any of our other sister states, Idaho or Colorado or Montana. What we can do is work around with those other states on agreements that implement the compact and respect its obligations and restrictions and what we get out of it. So I think once, I think the committee got comfortable that they already had that authority. And so that bill did not come out of the House Ag, or excuse me, Senate Ag Committee.
Mr. Chairman?
Yeah.
I've been watching with interest in being in Arizona, the falderall about the conservation plan there. And I would think that would be a procedure, what you're entering into now with the conservation plans. So you're not amending the compact, are you specifically?
Mr. Chairman, Commissioner Purcell, no, we are not. What what the drought contingency plans contain, especially for the upper division states, are the ability for us to get up to, I think, 500,000 acre feet in free federal space in the crisp reservoirs if we ever develop a demand management program. That's the one thing that we get. The other thing primarily that we get out of the drought contingency plan is the ability to be at the table for drought operations of those same reservoirs if we have to move water down to Lake Powell to maintain its power pool. Arizona, it's interesting you bring this up, and these agreements, by the way, are still a subject of heated discussion, especially in the lower basin. In Arizona, they had to go get legislative approval to sign. And the reason for that is they have a law that says if we give up any claim to water, such as they would have to do under the drought contingency plan, Arizona being the junior right in the lower basin has to forbear use, give it up in order to save water. They have to say, we will give up a claim to water. Their legislature or their laws say, if you're going to do that, you have to come get our legislative approval. That was what they needed in Arizona. And they got that right at the end of January. In the upper basin, we're not forbearing any use under the compact at all. Wyoming still has our 14% of 7.5 million acre feet a year, strictly speaking, or 14% of whatever we use or the upper basin uses in a year. None of that got affected. None of those numbers in the compact are affected. So yes, I would call it an agreement that implements certain practices without giving up any rights or obligations under the compact.
Certainly a political nightmare in Arizona, reading it in the paper anyway.
Nightmare has shifted across the border into California at the moment. So anyway, Mr. Chairman, I'll continue. Senate File 42 was a bill that sought to require Senate confirmation of the water superintendents in the state engineer's office. These would be the 4 water divisions, and their current incumbents are Brian Pugsley in Torrington, David Schroeder up in Sheridan, Lauren Smith in Riverton, and Kevin Payne in Cokeville. And this brought a pretty interesting debate, I thought, because we ended up digging up a lot of history about water superintendents. Turns out that until, and I didn't keep this particular note, but until I want to say about 1981, I think that was about the right date. They had been, what's that? 77? 71. Thank you, Senator Hicks. They had been confirmed by the Senate, and they had 4-year terms. So from the beginning of those positions until 71, they had been Senate confirmed with a 4-year term. This bill sought to require Senate confirmation and give them a 6-year term. In 71, the laws changed a little bit so that it took the confirmation away, took the term limit away, but it was clear it also added them as positions, I believe, under language it says the governor can remove any of these positions. So they became purely at the pleasure of. They are state employees. They still go get personnel evaluations every year, but they are at will. These are not regular employees. These are at will type of employees. And so the debate, I think, around the bill became, is that sufficient, or should we have, additional oversight? Do we need confirmation? Do we not? And that's the policy call that this bill raised. At the end of the day, it did pass the Senate, went to the House, and then did not come out of House Ag, but it was a close vote, 5-4. So the notion that these positions need Senate confirmation was really the philosophical question that this one raised. And is that oversight needed? There were arguments that it was, and perhaps arguments that it was not. The question, I think one of the ideas that came up, and there were voices on both sides of this as well, were if these require confirmation, does that politicize the position or depoliticize it? And it was pretty healthy debate on both sides of that question. At the end of the day, that bill also did not pass. So anyway, that, much like the confirmation of compact commissioners, it raises the philosophical question, what do you want your policy to be? Do you want to let the governor make these appointments, or do you also want to require Senate confirmation of them? So
I call that micromanagement.
Well, Mr. Chairman, at the end of the day, I thought if there is a reason for a person not to hold those positions, I have never seen a governor not remove a bad actor. They don't need that. So if a case is made, whether you're confirmed or not, I think that position can be replaced. And so confirmation also does not guarantee that whoever is in that position remains a good actor after year 3, for example. So you take your pick. What would you like to do to make sure these people are in those positions? We have recently had some superintendents that have served for quite a period of time. Craig Cooper over 20 years, Mike Whitaker over 20 years, Jade Henderson for over 20 years, Randy Tullis 12 or 13. Lauren Smith is currently in about to hit 16. But if you look over the history of time, They average about 8 years from 1890 up until present day. We did a check on that. And if you look back to before that law change in 71, there were quite a few changes in superintendents. So part of the discussion in committee was, what is the value of that experience? If they stay there longer, are you losing experience for no good reason, or is there a real good reason to let that person go? The nature of these positions is quite technical, and our qualified candidates, in my view, don't grow on trees. We might get one or two really highly qualified candidates every time there's an opening. So anyway, I thought it was a healthy debate. We had a good discussion of the bill. At the end of the day, like I said, it narrowly failed in the House. Okay.
Questions? Next.
Mr. Chairman, Senate File 87, temporary in-stream water use. This was a bill that amended both the temporary use statute and the in-stream flow statute. It was brought by primarily Senator Case, was the prime sponsor. And its intent was to allow the state, it would have changed the law so that you could approve some private water right holder temporarily changing his water right to an in-stream flow. It saw, again, quite a bit of good debate. I think it ran into a headwind largely from our agriculture folks in the room. And ultimately, Senator Case and his desire to get this bill passed just could not get over that. And it did not come out of Senate Ag. I think it failed 5-0. Since 2001, I've probably seen a dozen different bills come through the legislature that try in some fashion to tweak the in-stream flow law or make it so that you can have a temporary in-stream flow from some other water right. I believe you can do that in Montana. And as we reviewed the bill prior to the session, this is probably the one that would be the best as far as being able to administer, even though, I mean, this is the closest one to that my guys have seen that they thought they could make work. Even though you've still got to administer and work around return flows from other water rights. So when I testify in bills like this, I'm typically trying to say, does it fit within our water law and can we make it work? And at the end of the day, had this bill passed, I think we could have found a way to make it work. We would have had no choice. How well it would have worked, I don't know. Whether they would have maybe tried to put a sunset date on it, so we would try it for 3 years and then see what the ragged edges needed to be fixed, perhaps. But at the end of the day, it did not come out of committee. So that was the last bill that I was following, Mr. Chairman. So,
Any questions?
Mr. Chairman.
Ray.
I sat through at least the discussion in front of Senate Ag on this. And one of the points that were brought out by opponents to the bill point out that one of the underlying tenets of Wyoming's in-stream flow law is that those permits are owned by the state, and those are vested through Water Development Office. So one of the revisions in this, this is existing language, no person other than the state of Wyoming shall own any in-stream flow water right. End of phrase. That was to be amended with a comma, except that any person may acquire the use of an existing water right on a temporary basis for in-stream flow purposes as specified in the section. So there was some discussion, and I'll throw this out for the commission into the future, that, and I, as Pat indicated, these bills come forward every so often, and there's been a number of them, certainly in my 15 years with the state. The question would be, is in the future, a future temporary in-stream flow law, if those temporaries were vested with the Water Development Office, the state, that would at least remove that obstacle or reason for opposing this type of bill. So I throw that out as there may be a future bill that looks to maybe water development getting involved in these temporaries. Right now, we don't have any involvement with temporaries. So I guess, be aware in the future that that may be a future legislative proposal coming forward.
Any questions?
You're cooking.
Yeah, Harry and members of the commission and stuff. So if the management council hasn't assigned topics, but one of the topics that may be presented to them for discussion is just to look at the overall in-stream flow law for the select water committee. So that would be in conjunction with the commission, not specific to these temporary uses. Just to take a look back and see if there's other places that we can build some efficiencies in the process, but take a broad look at it. So I'm sure that this issue, as we put that, if management council decides to go ahead and assign this to select water, I'm sure there'll be people that are going to come to the meetings and probably advocate that we look at this temporary in-stream flow law also, but that's not the intent right now. It's to just look at the overall in-stream flow law and more than anything else, see if there are some ways that we can more efficiently get through that process the way it's bifurcated between the three agencies now, Game and Fish, Water Development, and the State Engineer's Office. So just an FYI, if they do sign that on March 22nd, it'd be something that we would be working on as some of our joint meetings with Water Development.
Any questions?
You want to move that up? Or?
Well, no, I don't need to be here for the whole thing.
Okay, I guess we're down to project updates.
So, Mr. Chairman, Pat may have a comment before he leaves on the Savory Creek in-stream flow filing.
Since we're on that topic, Mr. Chairman.
Number 9.
Yeah, I just wanted to make a remark. I don't need to be here for that discussion, but I wanted to remind the commissioner if, because I think Harry may have told you, but we had a couple of hearings on 2 of these within the last month, one on the Shoshone River, one on Savory Creek. These had been around for some number of years. And to get them moving, and Game and Fish certainly as one of the 3 state entities that is involved in these, really wanted to, especially on Shoshone, to get them moving. Both of these, to the extent you have any interest in commenting on either one, I believe they're still within their 30-day comment period following the hearing. Now, the commission, so you have certainly, and Harry knows the dates, I'm sure, on both of them. They were held in the last week or 2 of February. I would say that however your discussion goes later today, you are the applicant, essentially. And however you may want to comment on either one, I will not be sitting in my chair when those ultimately are dealt with in terms of approval, denial, whatever conditions, whatever gets put on that final permit, if and when it's issued. And so I don't need to be a part of your discussion. I wanted you to make sure you were aware that comment period is still open. There is no statutory time frame from the end of the comment period to the issuance of a permit. And so I don't think there's a big rush to get either of them signed immediately. But certainly now that we're in the comment period, if you need to take advantage of that period, please do.
What were the comments received during the public hearings on these?
Mr. Chairman, I was not, Commissioner Purcell, I was not at either one of the hearings. They were, the hearing officer was staff. And frankly, I think, and I don't think the Savory Creek one was held in the Bags country, and it was, unfortunately, the way the schedule worked out, it was also while the legislature was still going on. I don't think, at least in terms of anecdotal reporting back from staff, that either one was hugely. There was some discussion on the Shoshone River about making the numbers bigger, and a little bit of confusion, I think, between understanding what the in-stream flow permit does and what the winter release agreement does that we have with the Bureau up there. On Savory Creek, I could probably go get a copy of the transcript and take a look. I had not read through that one yet, sir.
I was.
You were there, so go ahead.
So, Mr. Chairman, Commissioner, on the High Savory application, there were questions as to, is this really needed? We certainly could, if you would like. So let me, so I attend.
May I interrupt just 1 second? Could you ask those on the phone to mute their phones? Because we're getting some really, really bad feedback. And from
Members, commissioners on the phone, if you didn't hear that, we're getting some feedback from phones. If you could make sure your phones are muted, then that gives a better broadcast signal to go out for our internet broadcast. Please do that.
Can we test them to see who's being heard?
So, okay. So I'm told, Commissioner Lancaster, you're getting the feedback. I don't know if any other commissioners are.
Well, we're hearing it here.
Yeah. Are you hearing some feedback?
Oh, yeah. I don't know. It's just scratchy and a lot of stuff like that.
yeah, and what's happening is because that microphone's so close on the recording, it's really.
So I have manually muted him.
But yeah,
No,
so
I've manually muted
we
Commissioner
can hear
Lancaster,
everybody.
but if they do it themselves, then they're free to answer questions or ask questions when need be. But then we don't have to mute them on our end. So if they'll just mute their own phones.
So Kellen, is your phone muted?
Yep.
Keep it muted, I suppose, until you do want to speak, then unmute and we'll go forward. All right. So, Mr. Chairman, at least the Savory Creek in-stream flow filing, again, there were questions on to whether it was needed because the reservoir, by virtue of its 404 permit, is required to provide to make up for natural flow to assure that there will be a 10 CFS flow from the dam or from the gauging station immediately below the dam of 10 CFS in the July 15th to September 30th period. That's a 404 permit provision. We have to meet that. Part of that time is obviously the irrigation season. So when irrigation releases are happening from the reservoir, that 10 CFS is equally or exceeded all the time during an irrigation release. We don't have to worry about it. But when the irrigation flows are either haven't started from July 15th on, or late in the season when they may be out of water or cease irrigation, then the natural flow coming through the reservoir, and another provision is we cannot store water unless there's a natural flow of 12 CFS coming, more than 12 CFS coming into the reservoir. So in those conditions, we are required to supplement so that we have at least 10 CFS during that period. The in-stream flow application also says that at other times of the year, if the commission decides to release water, that it would also be protected. And the protection of this in-stream flow is tied directly to the 1,000 acre-foot storage reservoir for environment and municipal. That if the water comes from irrigation, obviously it's headed to irrigators downstream. That water could not be protected under the in-stream flow filing. But if it comes from that environmental and municipal account, it could be protected up to 10 CFS. And so there was a lot of those kinds of questions on how it would work, but there were questions on do we really need it, because there's a 404 permit provision that says you got to release the water during this time frame. And the answer to that question, as provided by the Game and Fish, is that once it's released from the reservoir, it's subject to appropriation. And so the in-stream flow will, in essence, protect it downstream to the reach. And the reach is defined basically from the dam down to the confluence of Savory Creek and Little Sandstone Creek. And so those were the discussions that took place at the hearing. And then Senator Hicks and I have had some conversations about his concern with this filing, and that's probably appropriate if you want to just jump right into that at this point.
Can I have a question, please? I can't remember how many intervening appropriators are between the two down to Little Sandstone Creek.
Mr. Chairman, I believe there's 2 head gates in the and Senator Hicks, you may have a better. I think there's 2 head gates.
There's 2 existing head gates, but there's some additional water rights that are serviced down there in the canyon. I think they're Man and Ivy is the point of diversion on those. It's not clear whether those are actively being used or not, but I know there is a plan. There's been an application filed with NRCS to put a diversion back in there to activate those water rights. So if that's the case, there would be at least 3 that are currently permitted water rights. And then there's some other ones, but they're on the tributaries, one on Little Savory and another one on Coal Gulch, but 3 right now that would be actively involved in the send stream flow.
Follow up,
Mike?
have we calculated what the impact would be to our 1,000 acre feet?
Well, if you do, so the right as structured, it talks about July 15th to September 30, or it says at other times during the year. So it could be at any time during the year. But if you do the calculation of 1,000 acre feet, and of course that has a municipal use in it too, that will take away from that account. And Jason, I haven't run the numbers lately, but if we're talking 700 acre feet left in that pool, that you're not going to be able to do that from July 15th to September 30, or there's just not enough water to do that. And again, that's assuming no natural flow. If we have natural flow into the reservoir, we can take advantage of that in meeting that 10 CFS requirement.
And if you just did the simple math, that's 75 days, July 15th to September 30th. 10 CFS a day is 20 acre feet. That's 1,500 acre feet to meet our permit conditions.
Mr. Chairman, does Bags use the water?
We have a contractor here in the audience. Let me say that we have a contract with the Conservancy District to deliver 14,000 acre feet of water per year for irrigation and municipal. The contract does not stipulate a difference between or certain amounts for either of those uses.
Thank you.
Anybody else?
Mr. Chairman, I'm just going to, if you don't mind, I'll just weigh in very quickly, and then I will probably depart. Certainly as you're in the comment period, whatever you decide to do, I think would be welcome. We don't have a lot of comments on either one of these yet. So one thing I find interesting in reading transcripts of a lot of these hearings is people, and it's just because we don't have that many of them, often opine on whether or not, I don't necessarily agree with a number here or a number there, and maybe this ought to go up or down. And just to understand, what we take to hearing is one application. And the numbers at that point are unchangeable, absent pulling that back, doing something different, filing a different application. The calculus there is, what does that do? Is it a new filing? Then you sacrifice your priority date. So just when we get questions in hearings that this number should be bigger, well, and I think we did hear some of that. I don't think we had a whole lot of the ag community testifying in Cody at the Shoshone River, but we had a lot of the fish community. And we can't do anything with the numbers that are in front of us. We take the hearing or the application that we have to hearing. That's what we have to work with. And so you folks as the applicant on both of those, in essence, whatever you choose to do before they're granted, you're still welcome to do that. So I'm going to probably leave the meeting at this point, and you can, to the extent I still represent the person that sits in the chair that may decide on this, even though I probably won't be there when it does, I should probably depart. So it's been a real pleasure over the years.
I have one more question.
Yes, Mike.
What was the result of our feasibility study on this? As far as the study that was completed, we were required to complete on every in-stream flow, do you recall?
Yes, the feasibility study, because this is an in-stream flow from storage, did not look at any natural flow derived into this basin or anything like that. It was strictly, is there a storage account in the reservoir? The answer is yes. The volume is 1,000 acre feet as the application applies for. And we gave some statistics in terms of how often the reservoir has filled, as well as then the irrigation pool fills last in this reservoir. So giving the history of the reservoir, we showed that in fact water has filled this pool through the entire life of the reservoir. And so the feasibility then, is there water available from storage for this in-stream flow? And the answer was yes.
Any other? Mr. Chairman,
Mike?
so how does natural flow come into this then? Even if you would need natural flow to meet a longer in-stream flow? Is that what you were saying here?
No, the nature of the application is it's just from storage. It is a storage application only. The way natural flow comes in is if we have to meet this 404 permit requirement, we can use, it doesn't call out just storage water, we can use any natural flow that's coming into the system as well as then supplementing with storage. But we just have to assure a minimum of 10 CFS July 15th to September 30.
Mr. Chairman, just a follow-up on that, Harry, because that under that scenario, that becomes a direct flow because it's no longer out of storage. So the in-stream flow, as I understand it, would be debited only out of that storage. The scenario that you just described, say there's 5 CFS running in, and we have to release 10 out. And I want to ask this question while the state engineer is here. The way the application says it has to come out of storage. What you described is that would be split from a unappropriate or a direct flow and a storage account that would be the in-stream flow filing. And I don't think that's correct from a standpoint of the actual administration of that. And so I'm curious as to what the state engineer would suggest on that.
Well, so Mr. Chairman,
and permit conditions are different than the in-stream flow filing.
Exactly. And so in this scenario, and this question was, well, I don't know we got into this depth at the hearing, but there were a number of questions. The application for the in-stream flow is just from storage. So the scenario that I'm describing is for the 404 permit compliance. If we have 5 CFS flowing into the reservoir, we cannot store that water. We cannot store until there's at least 12 CFS coming into the reservoir. So from a reservoir accounting standpoint, that 5 CFS is going to move through the reservoir. If we get into this July 15 to September 30 timeframe, and let's say natural flow is 5 CFS, and that's the only natural flow in the system, then we are required by the 404 permit to supplement that and make sure that it is at least 10 CFS flowing out of the reservoir. Of that then, 5 CFS is coming from storage. That is the only portion that can be protected by this in-stream flow. It's not a natural flow filing, so it's only storage. If it's only 1 CFS being provided through storage, that's all that can be protected. And that's just the nature of the water law, and I believe that's how it would be administered by the state engineer's office. And I think that may be part of the confusion, but I would much prefer that we have natural flow that can meet that 404 permit requirement, but in those times that it's not, and we have to supplement with storage, then this in-stream flow would allow for protection to move that through the defined reach down to Little Sandstone Confluence. And that's, I think it does get confusing in that regards, but this application is strictly for storage water.
So, pardon me, Mike. So if in the instance you do have to pass natural flow, would this in-stream flow right protect it in the river? Was passed specifically for that purpose?
Mr. Chairman and Commissioner Purcell, I'll try and answer that in a generic sense. To the extent that we have, and our guys would understand this, and this decision would be made by the commissioner first on the ground, but they would understand what is coming out of the storage account is what's protected with that instrument, that permit. Any natural flow being passed through probably would be allowed to be diverted before the end of the reach. The storage component coming out is what would be shepherded to the end of the reach, perhaps with losses, depending on what that is.
So, Mr. Chairman, not to want to confuse things, but let me give another example. If there is 5 CFS of natural flow in the system, and we as the reservoir managers, and I'm looking to Jason because it is Jason and his crew that manage those releases, decided that we wanted to release 10 CFS from storage so that we have a total of 15 CFS below the reservoir. This proposed filing, the in-stream flow filing, would protect 10 CFS as it's being released from that storage pool. Has nothing to do with the natural flow component. So one of the head gates that we're talking about could certainly pick up 5 CFS of natural flow, but the commissioner, water commissioner, would be then hopefully in a position to say, no, there's 10 CFS of storage. You have to let 10 CFS, less the conveyance losses that are occurring as well by those head gates. But the natural flow is not affected by this application.
How is this different from voicing all the farmers in the area? They get the in-stream flow, but when anything above that, they need water. They have to buy that from the Bureau.
Mm-hmm. Yeah. In that case, it's contracted, and Game and Fish does not contract with water development for any of this storage water. They're relying that at certain times of the year, there may be releases from storage, so we have to meet a 404 permit requirement, and they would like to tack on the in-stream flow to protect it downstream from the reservoir. The 404 does not do that. And that's why they view it as insurance to provide water down through this reach for fishery purposes.
Mr. Chairman, just another piece of clarification. We're using storage as a general term, and it's storage from the environmental pool, not if we're releasing water for irrigation to the district, it would not be protected out of storage.
Mr. Chairman, I'm going to.
Adios. Good seeing you, Pat.
Good.
Take care, Harry.
See you tonight.
On.
All right, Mr. Chairman, and it's unfortunate. I prepared a series of exhibits for the commission, but the vast majority of you are on the phone, so you're just going to have to bear with us. You did email those, so thank you, Katie. So with that, first, what I'd like to do to address this is you should have a packet in front of you. The first one's called Exhibit A. This is Article 10 under the in-stream flow laws of the state of Wyoming. And the reason that I bring this to you is because the current filing is, would ask for some clarity from the office, Water Development Office and the commission here on some of these. So under 41.3-1004, this is where the Water Development Commission has to look at and determine the storage feasibility and the report to the Game and Fish and the legislature. So as you'll see is the first thing that's underlined here. It says the Water Development Commission shall determine the feasibility of providing in-stream flows for the recommended segments of the stream from unappropriated or existing storage facilities. And so the question I have is as to whether this current study complies with the strict constructs of the law is when I went back and I looked and I went back through all of 2018 and partially in 2017 and went back and looked at the agenda and the minutes from the commission meetings. I couldn't find anywhere where this was on the commission's agenda or in the minutes. Now, I only went back to October of 2017, so I don't know, in fact, whether the commission has acted on that or not, but that's the way the statute reads, and it may have happened before the October of 2017 meeting, but I could not find anything there. So that's one question, is if the commission has, in fact, made that determination on the existing storage facilities. So the next thing you'll see underlined under there is it says the feasibility study shall estimate the cost of providing any required storage and such other findings and conclusions as the Water Development Commission deems appropriate. And the discussion I've had a little bit with the director is I do think, and this is specific to High Savory, but it may also apply to Buffalo Bill. But there's a difference between the regulatory amount that's applied or required for releases, and then when the department comes in and files an in-stream flow on those later on, is the question is should they participate in paying for the cost of that storage if in fact, even though the Water Development Commission has the water rights, they're the ones that petitioned and asked for those water rights. And certainly because we're bringing on that use, it's something that I think that ought to be discussion by the commission, specifically with High Savory. It might have broader applications going forward as if they're going to file these in-stream flows, should they participate in the cost of that storage. And then lastly, if you go to subsection B under this, and this says the Water Development Commission shall make a report to the Wyoming Game and Fish Commission. Yeah, I did not look to see if in fact that had taken place. And then it says also the legislature outlining their findings. And I did go back to the 2018 and the 2017 legislative reports from the Water Development Commission to the legislature, and I could find nothing in either one of those reports specific to this in-stream flow filing. So, and again, I maybe didn't exhaust the record, but at least for the records that I examined, both minutes, agendas, and then also the last two previous years' legislative reports, this information on this in-stream flow filing that I found was not submitted to the legislature. And Harry, I don't know if you want to address that before we go on with this, but quite.
Chairman, I'd like to address all three of those questions.
Run straight down the list.
Okay. So with regards to the commission providing the feasibility study, and so now we're getting into our operations. We have a set of rules and regulations, and I believe it's chapter 8. And the commission delegates the following administrative duties to the office, and the office shall provide periodic progress reports to the commission. So a couple of the items that are listed, first is file applications in the name of State of Wyoming for permits to appropriate water for in-stream flows in those segments of streams recommended by the Game and Fish Commission. So the commission Water Development Commission has said, at least office, we want you to do that. So there's not been an action direct that the commission took an action to say, we're going to file these applications, or the same thing as the feasibility study. The second item, and again, this is a task of the office as delegated from the commission, administer in-stream flow feasibility studies and report findings to the Game and Fish Commission and legislature. So the commission is not necessarily in the loop as those documents are finished and submitted on. So that's the first question. And the reason why you won't see it on commission agendas is because that's been delegated to the office. The second question, the cost to provide storage. I believe that statute in its construct is really getting to when we have a natural flow, in-stream flow filing, that feasibility study can include the cost of providing storage in that basin that ultimately could provide or meet that in-stream flow requirements. Because this application is strictly from storage and it is an existing reservoir, I don't believe that it really is warranted that the commission would want to look at other storage sites to provide a in-stream flow from storage out of High Savory Reservoir, if you follow what I'm thinking. So I'm not sure that provision really applies to stored water. from existing storage. And then the last point, or the third point, is our feasibility studies, once prepared, are submitted to the Game and Fish Department. We believe that they then move those up to the commission as warranted, or it may be a delegated task in the Game and Fish Commission. But this feasibility study has not been provided to the legislature. It is, and Senator Hicks is correct. It probably most appropriately should have ended up in a legislative report that we make annually to the legislature. Here are the following feasibility studies that have been completed, and we have not done that.
Thank you. And then, so if I can go on, Mr. Chairman. So there's really three aspects that I wanted to discuss with the commission today. One was the legal aspect.
Are we on page 2?
So that was Exhibit A. So there's a couple other things that I think, so factual, and then some discrepancies and inconsistencies in the in-stream flow filing as it exists today. I did go back to the enabling legislation and pulled that out and from the 1993 construction projects. And if you flip over under Exhibit A1 to the second page, it says the purpose of the project is for agricultural, municipal, and domestic water supply, recreation, environmental enhancement, and mitigations for Stage 1, Stage 2, Stage 3 trans-basin diversion projects. Just I want to bring your attention to the fact that it did not call out in-stream flow as one of the beneficial uses of water under the original enabling legislation. So if you go to the next one, which is labeled Exhibit B, this is one of the issues where it starts to get a little confusing. So if you click on and you go to the website and you click on in-stream flows, this is what comes up, and it shows in-stream flow filings for Savory Creek. And this is what's on the web page. I downloaded this just a couple of days ago, and it shows on here that the in-stream flow filings for Savory Creek are for 10 CFS for 12 months out of the year. So that's what's out on the website. If you flip over to the next page, this is the actual study that was conducted by the office. Again, I don't know whether the commission looked at it or not, but this is the study that was commissioned. So when you go to the actual study, which is the third page there, it says in-stream flow applications. It says when storage is available, release up to 1,000 acre feet of high savory municipal and environmental pool. I want to bring your attention that it enumerates where that water is coming from in the municipal and environmental pool, and then released as necessary 10 CFS from July 15th to September 30. I'll talk a little bit about that 1,000 acre foot a little bit later. And then the fact that what the study says here and what's on the web page are inconsistent. On the first page, it said it would be 10 CFS for 12 months out of the year. And then the study says it's only from July 15th to September 30th. It says additional releases may also be made from said municipal and environmental to augment stream flows as approved by the commission that do not conflict with the contractor's reservoir supply at other times during the year. That's a broader discussion at some point in time that the contractors would like to have with the commission. Next page just flips over and shows you how those water rights were actually filed, and gets to the conclusions down there. And then at the last page on that, page 2 of 2, it says, therefore it is concluded that an adequate supply does exist for this in-stream flow application. Keep in mind, that's for 1,000 acre feet out of that M&I pool. Then this is the data that was actually at the public hearing. So if you flip to the last page that was presented, and again, it's also on the website, it says high savory area capacity data. This is extremely confusing. And so if you look at that and you look to the right and it talks about the elevations in those pools, and it says environmental evaporation water, 2,709 acre feet, and then district water, which is the contract water, is 14. But that table is inconsistent with what the water rights filings are. So if you flip, let's just go to let's just keep in mind, let's go back to the water rights filing earlier in the study. So if you flip back 2 pages, you will see there that those are not aggregated pools the way they're shown in that. And that was very confusing to the irrigators when they reviewed that at the public hearing. Again, the water rights are filed as 47.7 acre feet in the dead pool. There's 5724 for fisheries. And this is the water rights for municipal and environmental is 1,000. And then recreation and irrigation is 1561.2. So when you look at the actual water rights filing and then you look at the information that was provided at the public meeting, there is no water rights filings for evaporation, which is not inconsistent with most reservoir operations anyway, but it says that's coming out of environmental and evaporation water is 2709. So there was some confusion there at the public hearing as to what actually water was available or wasn't water. And then if you go over to Exhibit C, which is the next one, this is the public notice that was actually put out. And just want to highlight a couple again. It says it's release up to 1,000 acre feet. And 1,000 acre feet is going to be important as we move forward. So if you go to, should say Exhibit C. On Exhibit C, this was the public notice that was published. It says up to 1,000 acre feet from high savory municipal and environmental pool will be released for the 10-second from July 15th to September 30th. Then it says reservoir releases up to 10-second feet may be made from October 1st through July 1st. If you flip over to the next page, the study conducted by Water Development Commission is inconsistent with the in-stream flow studies on Savory Creek from Game and Fish Department, which this is also available on the websites that created some confusion here as to what study we're working off of. This is what Game and Fish recommended, was water releases primarily associated from a secondary storage right up to a limit of the 1,000 acre foot in the environmental pool. In-stream flows would be from 10 CFS from June 1st through September 30th, and then 12 second feet. Obviously, there's not enough water. If you do the calculations, that would have been 7,200 acre feet. But the point that I wanted to bring out there is Game and Fish had requested a different time period than what the Water Development Office or the Water Development Commission has recommended for those in-stream flows. So the next one is probably the most important one, is to flip over. These are the actual water rights filings on High Savory. And it also does mention, so if you go to page 2, it says for environmental purposes in the actual application. And then it says the remaining volume. So if you'll see the stuff that's underlined, and again, it says the environmental purposes and then reservoir releases made for in-stream flows / environmental purposes. So even in the application, it distinguished between in-stream flow and environmental uses. Then it says the remaining volume of the 1,000 acre feet of use dedicated for municipal and environmental purposes is reserved for municipal use and the Little Snake River. And that will come back when we get to the contract for the water. Again, if you flip over, and here's probably the thing that I think creates the absolute most confusion, is if you flip over, these are the state engineers' adjudication of the reservoir counts and what that water has actually been adjudicated for. So there's 1,000 acre feet in the municipal and environmental pool. And then there's the recreation and irrigation, and those are lumped together, 15,661. Fisheries, again, 5724 in the dead pool. But I would bring your attention to the underlined last paragraph in the adjudication of the water rights in High Savory Reservoir. It says no in-stream flow protection below the outlet of this reservoir is granted by the issuance of this permit. It goes on to say the permittee must obtain a secondary permit or other order from the state engineers to protect those flows being released And here's the important point that I wanted to bring your attention to. It says in stream flows or environmental purposes. Under the beneficial use, under the state engineer's office, the rules and regs and the statutes of the state of Wyoming, in-stream flows are segregated from environmental use. So again, if we look back to the water rights, there was no water rights filed in High Savory Dam for in-stream flow. There was for environmental purposes. When I questioned and made some inquiries into the state engineer's office as to what constituted environmental use under the beneficial use laws of the state of Wyoming, they said in the practicality of High Savory, that would be to meet the federal 404 terms and conditions for the permit of that dam, and that's that 10 CFS releases. That's what the environmental purpose was. It wasn't for in-stream flow. Now, not to say that you can't come on and file on those downstream of the dam because of the point of release of that. But again, that was some confusion as to there's no in-stream flow permitted use out of that dam. There is environmental flows under the permit. But here's where it really gets confusing for the irrigators and why subsequent, we had another meeting with the irrigators. And if you go to the contract, and I think Commissioner Purcell asked about the contract already. So if you go to the contract, and I didn't bring the whole thing because it's 28 pages, but if you go to the contract that the Water Development Commission has with the Water Conservancy District over there, it specifically says that for the purpose of the project is to provide late season supplementary irrigation for municipal water and recreation opportunities. You go down there and it says supplemental irrigation and municipal water. And then we go to attachment A. And this is where I absolutely can't figure out the inconsistency between what the water rights filings are, what the in-stream flow study says, and what the contract says with regards to High Savory. So if you go to the next page, which is page 6 of 12, it shows this is the non-marketable water retained by the state in that category. And it says minimum pool, which is the inviolate pool, environmental account that there's only 500 acre feet available in the non-marketable account retained by the state of Wyoming. And then evaporation is 12,009 acre feet of water. We don't know which pool that's coming out of, or is it prorated across all of the accounts in High Savory. And then we have miscellaneous, which we're not sure because there's no water rights filing for miscellaneous. But if you look at the asterisks on those and then go down into underneath where it enumerates those asterisks, it says which would likely exceed 500 acre feet of allocation of the environmental pool. That's strictly for the permit condition. Then it goes on, it says the municipal and environmental pool and the irrigation and recreational pools will be debited as necessary to meet miscellaneous releases under the permit. So in one document, we're saying we're going to take it out of the environmental and municipal pool. It's unclear because of the contract. So the next thing you'll see is the Conservancy District has contracted since the reservoir became operational for 300 acre feet out of the M&I pool. So as it exists today, there is only 700 acre feet of water that would actually be available for either releases, even under the terms and conditions of the 404 permit. And if those are not being met, the way the contract reads is then those are coming out of one of the other pools. It also says in the contract that there's only 500 acre feet reserved for in that M&I pool for meeting the terms and conditions of the 404 permit. So the public notice and the study said we're going to release 1,000 acre feet for in-stream flows, up to, assuming that it's stored. We have a contract that we've already sold 300 acre feet out of that, which means that there's only 700 acre feet that would be available. And then the contract says, but the state only reserves 500 acre feet out of that M&I pool for meeting the terms and conditions of the 404 permit. But they could go ahead and take some additional water out of either the irrigation pool or that recreation, which is 15,000 or 1,566. So when I go through all of this, it's confusing. There's inconsistencies between with the contract that you currently have as the commission, with the public notice, and I think there's some confusions as to how those water rights filings actually translate from an environmental, given the beneficial uses that were distinguished between in-stream flow under the permit and environmental uses. And I guess my discussion with the state engineer's office is they didn't necessarily concur that environmental water necessarily meant in-stream flow water. Their interpretation of it is that environmental water was only for the purposes of meeting the 404 conditions. So the only other thing that you have on there in the back there is it just shows you that both the town and Dixon's do have water that they purchased, and they have paid every year since the original contract was signed for High Savory. So I bring this to your attention not to say that we're necessarily opposed to an in-stream flow. It's just, number one, we don't believe that the current in-stream flow law has met the letter of the law from the standpoint that the study was never submitted to the legislature. The other question that I'd have back on those earlier points as to whether the agency can adopt a rule that supersedes state law. I don't think that's accurate. But that would be a legal question that would have to ask, even if the commission did delegate that authority to the office, whether that rule supersedes the state law that says the commission shall make that determination. So I think the legal aspects of the way this has been filed are incorrect. And then I think there's some confusion out there that certainly in the constituents that I represent, where's the water coming from? Because the contract says it can come out of the M&I plus the irrigation pool plus the recreation component out there. And so there's some inconsistencies across the board. What I've been directed from the irrigators is to bring to the commission that we would ask that you would recommend to the state engineer's office not to move forward with these filings until we'd complied with the letter of the law and had another opportunity. What the irrigators would really like to do is engage the commission, the Water Development Office, the Game and Fish Department and Commission, and the State Engineer's Office, and see if we can come up with a better approach. And in 2012 and 13, we actually entered into a memorandum of agreement with the Game and Fish Department and the Water Development Commission and provided 1,500 acre feet of water, if necessary, to maintain the fisheries below High Savory. The real problem with the whole application is minus the legal and the discrepancies, is the simple fact is that it doesn't address the best thing that can be done with fish. For a 5-year period back in 2013, 2012, we realized that the maximum temperatures on Savory Creek were in late June and early July. With this in-stream flow does not provide any additional water for whatsoever. At that time, we did operational releases to try to anywhere from 25 and up to 40 second foot, trying to get those temperatures down all the way to this reach. The irrigators at that time said they were willing to put up 500 acre feet, the water development 1,000 acre feet, with the stipulation that if we got into September and we'd exhausted those two pools, that we could encroach into the minimum environment pool for strictly municipal water. We would like to entertain those discussions again and see if there's something we can do better with the reservoir. I mean, fisheries is a big component of that community over there. This reservoir has done phenomenal things for Savory Creek and the Little Snake as far as fisheries, and it is becoming a little bit of an economic engine. So this in-stream flow does not even address those critical times, which is from mid-June to mid-July, for maintaining the optimum conditions for fish. But that would be a recommendation that we would like to continue these discussions. But at this point in time, the commission would basically table this application until we resolve the legal issues and then get some more clarity and hopefully enter into discussions with all the parties involved if there's a better way to operate the facility to maintain all the necessary benefits. So, Mr. Chairman, that's the question I guess we put on the table.
So, Mr. Chairman, I'll just provide some comments. The application was filed in 2002. And so the language that you're seeing there is, I think, reflective of we were viewing a new reservoir, not yet completed. Certainly that July 15 to September 30 found it into that language. And then it has kind of as an after fact, or if the commission directs that water be released at other times of the year. So there has been some controversy about this with irrigators, and that led to then the MOU that Senator Hicks mentioned, and I was party to that. Well, let me back up. I was not party to the filing of the application. I was not party to the contract, and to the extent those appear that there are discrepancies, I don't know how to fix that other than if you tear up the contract and we start over and go back to the original water rights. But the process of trying to come to an agreement between the irrigators, the game and fish, and water development was tried 2012, 2013. And that's the MOU. Okay. That agreement, the MOU, there was not full agreement that the parties could enter into that agreement. And so at that point, I moved on from whether there would ever be an agreement. One of the conditions insisted by the irrigators would be that if water was provided and adequately, and I believe it was 3 years, Senator Hicks, might have been 5, but I think it was a 3-year period, then the game and fish would agree to withdraw their in-stream flow application, really a commission application. That was rejected by the game and fish. So my thought at that point in time is we've got an application that was filed in 2002. Let's take it forward and have a determination by the state engineer. The application for in-stream flow does not dictate releases from the reservoir. Those reservoir releases are determined by the operator, the owner. And at this point, that's been delegated to Jason and his crew. They cannot come in and demand that we release water at any time during the year. And I'm talking game and fish. Now, if we get to a 404 permit requirement, we absolutely do not want to violate that. And so there are combinations of, we can use natural flow, we can use storage water. I think the point of the application, I believe, is that when we do release water from this municipal and environmental account, whether it has 100 acre feet in it or 1,000 acre feet, anytime that it's released, it could be protected by this in-stream flow filing. And that's the intent, to at least protect it. So we can go back and start from square one. As Pat indicated, you will lose your priority date in terms of a new filing. I think that would be unfortunate. But it is not, and I do agree with Senator Hicks that I think if we were to come to an agreement that in fact there could be more water made available for fishery purposes during the entire year, but that effort's been tried and it failed. It because of the conditions. If you want to go into those additional negotiations beyond that, maybe it would succeed. I don't know, but I'm thinking a filing that was made in 2002 that it is appropriate that the state engineer make a determination. Is this an in-stream flow that I can permit and approve? And I think we've moved it to that point. I will agree with Senator Hicks. We did not submit the feasibility study to the legislature, and that may be a defect at this point that we may want to put it on hold until we do submit that next December, in essence, through our annual or our legislative report. But I do think if water's available in that account and it's released, that the in-stream flow does simply that. It allows the state engineer to protect that water down to or through the reach. And it does nothing more than that. The fact that, and again, if there's discrepancies between water right and contract and the application for the filing of the in-stream flow, I don't think that those are fatal flaws or significant because it's only when water is released from the municipal and environmental account that it would even qualify for protection if this in-stream flow was granted by the state engineer. So of course, I'm departing tomorrow at 5 o'clock.
Can't get out
So
of here quick.
go forward after that. But I think that application's been there for that long, and I think it's appropriate the state engineer taking action on it.
Mr. Chairman, it's my understanding that there is an outstanding contract for the municipal and environmental water for 300 acre feet.
Mr. Chairman, the contract, I don't believe, dictates 300 acre feet. The contract says 14,000 acre feet for irrigation and municipal. If there's another contract between the district and those municipalities, that's something we're not party to.
You contracted 300.
Correct. And again, based on the water rights, that can't come out of the irrigation pool. That has to come out of the municipal and environmental pool. But I give you a copy of the last 4 years of payments on those. So they are, we subcontract or lease that water back to these two municipalities, and that is in place. So again, there's really only 700 acre feet available in that account now for this.
I don't know if I believe that, I agree with that. If you in fact have subcontracted part of your water for it, separate from, now if you would have contracted 300 acre foot out of the municipal and environmental account, then I understand that because we're a party to it. But what you do with your water is your business. It seems to me we got, number one, we got to meet our in-stream for our 404 permit. Second thing we need to do is meet our contract with the irrigators. Those are inviolate. So then the question becomes, what else we got and how does everybody want to use it? And and we would like to see all the documents concur. Did we ever get a supplemental water right for the delivery of the in-stream flow?
Mr. Chairman, that's what the in-stream flow application would do. It, in essence, functions as a secondary.
Okay.
Mr. Chairman, I would also ask that water that may be contracted by the district to municipalities is different from what water they may have used. And so are you being provided use records from the district or from the municipalities as to whether they're actually using that 300 acre feet, excuse me? Because I suspect there are times in the year where their normal direct flow water rights provide ample water, and the municipal contracting is insurance in those very dry times of the year, but how much water are they actually diverting? And 300 acre feet goes a long ways for the municipal population in that valley. So I don't know whether they're using it year round or for a part of the season. So then it gets further into the accounting as to whether they're actually using that full 300 acre feet.
Mr. Chairman, first to address Commissioner Purcell's concern, the contract does say municipal and irrigation, which anticipates that those are coming out of different accounts because that's the way the water rights were filed. It's aggregated as a total of 14,000, but because it enumerates in the contract municipal water and irrigation water, the water rights were filed that way. Yeah. I think it's implied that that's coming out of the municipal account and the irrigation count is coming out of that 15,666 or a little over 15,661.2 acre feet of water is where the irrigation water coming, but it's an aggregate in the contract. So I do think that was anticipated.
And I would agree that it would come, that's the permit on the reservoir. Correct. And it does have a municipal component. So, but then the question is it being fully utilized?
Why aren't we the one contracting?
It's a good question. That's not how that contract was structured.
Mr. Chairman, I can answer that. Because under the laws of the state of Wyoming, it does allow water conservancy districts to contract to municipalities for stored water. So when this was
It's
set,
water, it's not yours though. It says your contract's only 14,000.
well, but the reason it was set up that way is because the conservancy district is the contractor, and then we deal with all those other entities out there, and that's the way conservancy districts were set up, is they can contract for waters on municipal water under the state of Wyoming on the laws. So,
Any other questions? I guess we'll kick this horse around as much as we can today. Thank you, Mr. Hicks. We'll go back to. Okay, we won't leave it yet. In-stream flow. Staffer.
In this office, Chase Tavelli.
Do you have any more, Mike?
We had to do something. I don't know what it is.
Yeah, I know.
I need some guidance.
All right.
I would just make one comment, Mr. Chairman, is that every year around June 1st, we submit to the Conservancy District what water is available for their contract. And leading up to that, especially in the dry years when we know we're going to be short, we're working hand in hand with Senator Hicks as well as Game and Fish to try to make water go as far as possible and meet all the needs that are out there, both recreational and irrigation wise,
I think we have a good,
fisheries wise.
pardon me, Mr. Chairman, I think we have a good relationship with them, and I don't want the in-stream flow to be the cause of
Put 'em at
conflict in
odds.
that. So if this thing's in any way going to affect our ability to meet ag and municipal demands, no matter whose water it is, I would like to know that. What this, does this in-stream flow in a dry year impact our ability to meet our demands? And if we're doing something with this in-stream flow that does affect water supplies to the M&I in a dry year, then we have to either go back to the foot of the other contracts, or we don't provide the in-stream flow water.
Mr. Chairman, I think that's kind of a point I was trying to make, that the in-stream flow does not drive reservoir management. It does not drive when releases may be made. The in-stream flow filing application merely protects that water in the reach below the reservoir if it is in fact released from that account. That's what it's intended to do. But it does not drive when we might release it. Certainly the Game and Fish can say, gee, we could just sure use some more water, but it will be the reservoir manager that determines, do we have enough water to release it on a given day? We have a 404 permit that we absolutely do not want to violate, and we absolutely want to provide our contractors with water. That all said, if we do release water from the environmental account, then this in-stream flow would pick it up in essence and protect it through the reach. But it does not drive reservoir management.
Anything else? I guess nothing we do about it today.
Mm-hmm.
Let's have it. See what the commission thinks about tomorrow, and we'll go from there.
yeah, Mr. Chairman, again, this is a workshop, so you can't take any official action, but the request from your contractor here would be to, because of the legal aspects, or for no other reason, it hasn't complied with the laws.
Agenda tomorrow, is that on the agenda tomorrow too?
Mr. Chairman, it is not. You could certainly add it to the agenda if you want, or
I think we ought to add it. Maybe not going as lengthy as what we have today, but to do, Mike talked about his concerns, and as a guest, the senator can talk on body.
Mr. Chairman, does everybody understand that in-stream flow is not a demand on water, other than that required by the 404 permit? If that's truly the case, a lot of my concerns are alleviated. But politically, once you go down this path, there's going to be fishery pressure to provide it. But well,
we could run it through a short version tomorrow. I mean, the rest of the commissioners have heard what we talked about. So I would add it to the agenda tomorrow somewhere. And if the 404 permit will handle everything we need, then we don't need this.
Well, so again, I'll make the distinction. The 404 permit gets water out of the reservoir. It does not protect water downstream, because that water becomes unappropriated water available for appropriation. The in-stream flow intends to protect it during this channel reach, or in the channel reach.
it just protects storage water.
And that's the application that was filed is for storage water only. There could be a companion filed for natural flow. That would be a separate application, and I don't think it's reasonable in this case. But those are two separate types of filings. This one is for storage only.
Mr. Chairman, if I may.
Yes.
And I think what Harry said is absolutely accurate, but then you have to look at the practical application of what it does, and it does absolutely nothing. From a standpoint of protecting that water, is because any potential ground, and if those are familiar with it, it's in a canyon, and it runs in a canyon all the way down to the confluence with Little Sandstone Creek.
Nobody's going to tie into it.
I thought there were 3 intervening appropriators, Mr. Chairman.
But Mr. Chairman, those are already in priority, so they can divert this water anyway.
We couldn't divert storage.
Yeah.
Well, they are senior too.
They're senior, so they could call their water rights through. But again, back to if there's 5 second foot running in, they're going to get that. So they can only protect whatever that little storage, but that is still a junior water right to those senior irrigators. So that is available for diversion, even though it's a 2002 filing. So, but everything that's potentially irrigable in that canyon has got a water right on it. So the idea that this is protecting water, the question becomes is what's it protecting it from? Because there's no potential irrigable, any more irrigable ground that could be broke out in that canyon.
Well, if we do nothing, life will still go on.
That's exactly right.
So Mr. Chairman, at that hearing, after it was over, I did have a conversation with a gentleman that has at least one of these head gates. And he asked the question about enlarging those rights and how it would stack up against this in-stream flow. And so I think there is an interest potentially of expanding those uses. And if that's the case, in a current day filing of his to enlarge, he would be junior to this in-stream flow. So he did not like that aspect. So that's really what the in-stream flow does. It protects that water against future and yet undetermined uses. And it may be minimized in terms of this canyon and the geography, but it does protect it against future uses. And that's really what the in-stream flow will do.
Chairman and Harry, I guess I would question that, whether or not he could divert that water, because it was stored under priority and it's being released out of storage. Therefore, it's not natural flow. He could divert the in-stream, the water that's being bypassed, that's natural flow, but not the water out of the environmental municipal account from storage.
Chairman, I would contradict that. As soon as that water is released from the reservoir, the state of Wyoming has no claim to that water. It becomes unappropriated
natural
water.
Flow,
It's natural flow.
unless you have an in-stream flow right or what the secondary. Secondary protects releases from storage down to the
Point of use.
point of use. And this is the avenue, the in-stream flow right is the avenue to accomplish the secondary, as I understand.
Do we need it on the agenda for tomorrow? If it's not on there, would you like it on there? What?
Commissioner Lancaster suggested that maybe this be a topic when everybody can be present, because he said that communications aren't necessarily coming through that clear. That's just an email.
Okay, we could handle this in April or May, whenever that meeting.
May meeting?
Yeah.
Mr. Chairman, you could do that, but that doesn't meet the deadline with the state engineer's office for public comment. So that public comment deadline is March 28th. So if you do nothing, then it kicks it over to the state engineers, and most likely that's.
How about a simple letter to the state engineer requesting extension of the comment period? What would that do?
Would have to grant that to keep it open, or another approach asks that he place any deliberations on hold until the commission's had an opportunity to discuss it further.
Well, let's go that way.
Mr. Chairman, Harry, you've been under the tent of the state engineer's office. The information provided today by Mr. Hicks, will that be part of the consideration of the evaluation by the state engineer?
Mr. Chairman, Senator Hicks, were you going to provide that as part of the public comment period? So it will be part of the record.
We'll make that just part of the public.
Nothing better than, Mr. Chairman, than throwing it at the foot of somebody else.
Well, that's the best we can do. I mean, under the circumstances, I think. I mean, we have a problem there, and we better, but the state engineer will be the head outfit.
I would, Mr. Chairman, I would recommend, I'm not gonna make a motion or anything like that, but I think a simple letter that would say that we weren't able to fully vent this issue because of the weather, and would like an extension of his deliberations until we had the March meeting.
We can do that.
Okay, we're back. Where do we quit? No, are we on number
I'm
5?
pretty well rattled now. I'm done now.
Everybody else is gonna be mad now.
Okay.
Mr. Chairman, item number 5, project updates.
Okay.
As I am about to depart, I thought it only appropriate to discuss, I'll call them problem projects. I was going to name them problem children, but these are really problem projects, and I want to make you aware of those. The first one, and if you go to tab M in your notebook, you have an email, and I believe it was directed at commission members. So, Bill, you didn't get a copy of that. You got it in the notebook now. But I think there's some, I guess I'll offer this as kind of learning experience that we've had from time to time. And over in my tenure with the commission, we've had lots of discussions about the need to regionalize water systems. And so this fits exactly in that mold. Currently, the town of Newcastle provides water to an improvement and service district called Cambria. They have for a long time. And over the years, there's been a new development called the Sweetwater Improvement and Service District, which is, in terms of geography, Newcastle. If you move north, you run into the Cambria Improvement and Service District. And if you move further north, you run into the Sweetwater District. The Sweetwater Improvement and Service District had their own distribution system, and their source of water was a spring that actually flowed into an open pond before it flowed then into their distribution system. And at least the story that I had heard was that one year they found a dead deer in their pond. So that's their source of supply, and it certainly doesn't meet EPA standards by any means. And they entered into a study with Water Development, and that study ultimately concluded that they should connect to the Cambria Improvement and Service District. And that's about the time I came on board. And one of my first meetings was with the Cambria folks, and they said, we don't want to provide water to Sweetwater. and the Sweetwater people said, we want to drill a new Madison well. So we're on our own. And of course, they wanted water development to pay for that Madison well at the tune of, those wells are typically $1 million plus wells.
Okay, pardon me.
So the discussion then went forward that, and I had talked to Newcastle as well, and Newcastle was okay with providing water to Cambria that could ultimately be provided to Sweetwater. Newcastle has been really, I think, very upright and
Over backwards to take care of all of them.
and we have provided money to Newcastle to upgrade their system for this. But along the way then, Cambria said absolutely not. And then about a year later, Cambria brought an application for a new storage tank and some upgrades to their system. And I recommended to the commission no funding because they would not provide water on a regional basis. And that took a year or two for them to come back and said, okay, we will provide water to Sweetwater, but we really don't like you, Mr. Labonte, because you're forcing us to do something we don't want you to want to do. That aside, then Cambria came forward with their application for a new tank, pump system upgrade, and we put a condition in that project that they had to have in place an agreement with Sweetwater and Newcastle to provide water to Sweetwater. The project was funded as well as Sweetwater's then connection to the Cambria system. And those projects, Sweetwater is in essence done, ready to connect. There was a new piece of pipe that needed to be installed on the Cambria system that then connects to their new tank, and then the tap would come off to Sweetwater. That is under contract. We are now in a winter shutdown. Cambria could have turned water into the Sweetwater system. I made that request on behalf of Sweetwater to say, hey, there is a 2-inch connection. Can you turn water into the system? Cambria said no, not until we have our new pump station online and the system is complete. And that's where this email then comes in. And as you can read it, Sweetwater still does not have water. I would expect by this summer, they will be connected in and they will have water. But what you're seeing in the email, and I don't take this personal, is really the frustration of trying to get these entities, districts, to work together with a common goal. And they have not always worked in step in that regards, but it's been now going on a 7-year process that I've been involved with these 3 entities. And we're going to get it done this summer, but as Mr. Strickland indicates, it's not to his liking or in terms of the schedule. He is frustrated. Of course, as the email indicates, he is selling his property and moving on, but
Take a 10-minute break.
we may, yeah.
Let's take a 10-minute.
Good idea.
Why didn't you think of it before we started?
This one's so old. This is one I flushed right down to you, isn't it?
That's right. Why didn't Mr. Purcell handle this?
I did. I thought it was done.
There's lots of things we think are done, and we come back and
Ready?
I'm ready if you guys are ready.
We lost Bill. You want to wait?
He's right here somewhere.
He was talking to me.
Oh,
So
well, maybe we give him 5 minutes.
Let me take a
In that case, I could have one of those.
let me take a look and I'll get back.
it's going to go right to your hips.
Mr. Chairman, the next project I'd like to just visit with you is the Lower Norwood Improvement and Service District. And I have letters that I will provide to you, but I don't think they're under tab M. If you see a March 11th letter, I think they're on my desk upstairs. But this concerns the Lower Norwood Improvement and Service District project. This is also one that started out, we were hoping for a regional solution. The study indicated that the best solution would be for them to tie into the town of Ten Sleep's water system. I had a couple of meetings with the town of Ten Sleep. Senator Hicks joined me on a couple of those. Ten Sleep outright denied the ability for this district to connect into them. And so from that, we moved on with a project for them to drill their own well and then pipe that water down into, and at the time they had about 20 taps in their system, or what would be a new system. And the project moved forward. It's got a $2,390,000 budget. We're providing a grant in the amount of $1,696,900. It's about a 71% grant. The balance of that is being borrowed by this district from RUS, so federal dollars. And so we have started, the first phase of the project was to drill the well. And the well driller was out there this last fall and drilling the well. The district very much wanted to drill into the Madison Formation. The Ten Sleep, we believe, would have provided adequate water, but I agreed, okay, go ahead and drill to the Madison. So that well has been advanced to what we believe is the Madison Formation. The hydrogeologist said it is the Madison Formation. It's only about 10 feet into the Madison Formation, but it is providing Madison water. It's an artesian well that's providing, let's see, about 70 gallons a minute with a shutoff head of 80 or at 80 psi. The design flow for the district or for the project is 53 gallons a minute, so the quantity exceeds what the district needs. And the district pulled a sample of water while the driller was on site and was shut down. Had it tested, they felt that it had high iron content, and it was not Madison water, in fact, and I don't know who they were getting their advice from, not the hydrogeologist. But we then asked the consulting engineer to go ahead and make sure, flush the well as required before you sample. And they sent that water off to the lab, and we have those results back. Total dissolved solids 210. 500 is the kind of the requirement, or not a requirement, but the recommended limit. This is very good quality water. The iron content is non-detect. I think it's non-detect, but it's color, odor, not a problem. We believe it's Madison level water. The owner, sponsor, is still, I think, insistent on we want to drill deeper. And so I wrote this letter basically saying that if you choose to direct the driller to drill deeper, water development will not cost share in that deeper well because what you have meets your requirements. In this process, the owner, the sponsor, disagreed with the hydrogeologist and said, well, we want to fire you. The consultant in the process said, well, you can't fire the hydrogeologist because he works for me. And they said, well, we want him gone. And so the consulting engineer has now quit. And so I believe the well driller may have pulled off the site at this point in time. But this letter went out this week, and it's really to put us on record as if you want to drill this well deeper, that's fine, but it will be on your nickel because it meets all of the project requirements. Be advised that may be a future topic that comes before you because I think there was kind of a thinking, we'll just drill this well deeper and we'll come back to Water Development Commission for additional funds. But the well is priced at about $200,000. The balance of this budget obviously is going to the pipeline system that will move water down this valley. And my concern is if we spend more and more dollars on this well, we won't have enough money in the remaining appropriation to build out the transmission system. So
Is that well tapped enough to where it's tied in and all they have to do is put a house around it and hook the line on? Or will it need a tank?
They plan on this design, at least the previous consultant now has resigned from this job. They were planning on a tank, a pressure tank at the end of their system, not at the wellhead. So right now we have a wellhead in place, but nothing more on this project. And the design for the transmission line is not yet complete. So now a new engineer means additional cost, potentially a new hydrogeologist in terms of completing the well. So it's somewhat of a mess at this point in time, but I wanted this letter to
Got to get tough with them and tell them this is it.
We are not providing additional dollars on this project. So that's what, and we do have a copy of that letter for you or going towards you. The next project, the third project that is, I'm disappointed with where we're at, but Big Sandy Reservoir Enlargement. This is a project that's owned by the Bureau of Reclamation. We've gone through one of our commissioners is Lab. He has experience with the Bureau of Reclamation. Project to enlarge it, increase the reservoir or the spillway height 5 feet. Jason, what was the additional yield? 13,000 acre feet. Because it's a Bureau facility, we could choose to design it with our consultant and provide it to the Bureau for their review, or we could just have the Bureau of Reclamation design the project, which we felt was probably best because they're, in terms of going through multiple gyrations of their review, fixing it, their review, fixing it. So the Bureau is designing it. Their 30% estimate, 30% design was about 10.2 million for overall project cost. And this project qualifies for Colorado River Basin MOA funds. So we have allocated 10.2 million towards that, or about that, towards this project. And we just received here, well, I got this letter here this week, but we knew it was coming. They are now at 90% design, and the project cost is increased from 10.2 million to 16.2 million. It's an over 50% increase in the cost. And their letter enumerates a number of issues that they have had, but the project now, we do not have enough funding as currently allocated. So we are, by this letter, $6.2 million or $6 million short in the budget. We have an additional amount of unobligated MOA funds in the amount of about $5.4 million. So we have MOA funding that will cover most of that shortfall. And we do have a water development account 3 appropriation when we were thinking of funding this just with account 3 that totals $8 million plus that we are not using, but could be brought in to make up that difference.
Part of it anyway.
Part of it. We would prefer to use MOA dollars, but to the extent we allocate all of those, we're going to still be short a few $100,000. Those are all actions that the commission will need to address in the future. Again, I won't be here, but I wanted to brief you on this. And Jason will be here, so he can handle all of this. Disappointing. I think we've had some experience with the Bureau in terms of their designs and costs keep going up and up. And my direction to Jason in dealing with the Bureau is we do not want them to stop the design of this project. Keep the design going. There's more than adequate money in the budget right now. And of course, we're dealing with engineer estimates. What we really need to do is get this project to bid. So we're dealing with real dollars, real construction costs, and then we can sort out ultimately how it's going to be paid for. There's adequate funds that we have access to pay for the whole project, but I don't want the Bureau saying, well, until we have this project fully funded from the state's perspective, we can't go forward. And they've done that to us once on this project. But so there's my 3 project updates.
Mr. Chairman, how did this compare with the Pathfinder modification? Did we use Bureau? My recollection is we used our own consultants on that.
Mr. Chairman, we did. I would defer to Commissioner Purcell.
Mr. Chairman, Senator Hicks, there's no way to skin this cat when you're working with the Bureau of Reclamation. Particularly we had the good ones. We had the North Platte regional. This is a little different. They're this Salt Lake.
Provo, Upper Colorado River.
Yeah. Have we had a chance to review anything at all?
Mr. Chairman, yeah, we've been involved in, the reclamation and their 30 pairs of belts and suspenders, and that's where.
That's my point here. I suggest that these are worst case estimates. How was that diplomatic? Yeah. But Mr. Chairman, Mr. Director, do we need as a commission to support the means by which you are suggesting that if in the budget goes up, we have a means to meet that? Do you need that from the commission, or are you comfortable that Jason can handle it with a letter?
So Mr. Chairman, Commissioner Purcell, at this point in time, it is not teed up for a decision, but ultimately we will need commission blessing to obligate the remaining portion of MOA funds. And at that point, we have the water account 3 funds are already appropriated. It may mean an agreement between the district and commission goes forward at some future date. But I think the big thing is, and probably at your May meeting, you will be asked to agree to obligate the remaining portion of MOA funds towards this project.
Thank you.
Mr. Chairman, that's, if you want to move on. Okay.
I don't see
Got any
anybody
good
raising
news
their
coming
hand.
Yeah, maybe, Mr. Chairman. Item 6, Platte River Recovery Implementation Program. I just wanted to give you a short update. I am, and I guess, Bill, for your benefit, this is an endangered species recovery program, operates on the Central Platte. It's important to Wyoming, Colorado, and Nebraska because in the very early, I'll say the 1990s, the Fish and Wildlife Service made a determination that they needed 417,000 acre feet of water from the Platte, which is in essence fully appropriated for endangered species purposes. That led to, in essence, the first increment of this recovery program started in 2007. It is set to expire at the end of 2019. And so we very much want this program to be extended because it provides ESA coverage for water use in Wyoming, Colorado, and Nebraska. And the program is running very well, but it needs to be extended. So the good news is I have been working with Senator Barrasso's office. I believe that the senator will be sponsoring the legislation to extend the first increment 13 years. We've got to get that done this year, obviously. In that capacity, Governor Meade issued a letter that it supported extension of the program. And the senator's office asked if Governor Gordon felt the same. So in working with Governor Gordon, he has provided that letter to the senator saying that I do support the extension of the program. So that's going forward. So now we're starting to work on what the legislative efforts will be in terms of contacting all of our legislators in the 3 states and moving that program forward. But we're waiting now for Senator Barrasso to actually sponsor the bill. It'll get a bill number, and then we'll be able to talk to our other legislators in those states. And I have offered to Governor Gordon as part of my transition that I will stay on, if he is so inclined, as the governance committee representative for Wyoming. He has taken that under consideration. I have not heard one way or the other in a formal sense that whether he will do that, but I'm certainly available for that. And that'll allow a new director, obviously, to focus on in-state water development issues. But that'll be entirely up to Governor Gordon in terms of the transition. Any questions there?
Mr. Chairman, one question, Harry, if we're going to go through the congressional reauthorization of the PREP, my recollection is that the EIS for that still calls for 400 and some thousand acre feet of water for endangered species. Was there any discussion as to put a congressional cap based on what the PRIP has done versus what the EIS has done? But we're still under that 400 some thousand acre foot potential call under the Endangered Species Act. Is that correct?
Mr. Chairman, Senator, you are correct that 417 is still out there. What has transpired in the first increment is we were not able to put the first increment water goal in place, which was 130 to 150,000 acre feet of water. We got to about 90,000 acre feet. So going forward in this extension, the service has said we will agree to rather than 130 to 150, reducing that to 120,000 acre feet with the qualification that if the science shows we need more water, then it will add 10,000. We'll go back to 130. What the service is saying is we haven't met our water goal in the first increment, so we've not been able to test all of the science to let us fully look at this 417 number. But there is the effort now on this governance committee is that we are starting the path to look at the target flows for these species, which is what the driver was to get to 417. So we're starting that discussion, hopefully at the beginning of this extension, 13 years.
Mr. Chairman, just if we're going to go through congressional reauthorization, would it not be worth having the discussion as part of that reauthorization to move that cap? I'm just familiar with the whole Delta smelt debacle and how it cost billions and destroyed agriculture in the Central Valley of California. I don't necessarily trust their science.
If we take that approach, I would not recommend that approach. If we take that approach, we're going to lose the Fish and Wildlife Service in terms of their support of this, because they sit on the governance committee as well, and they're endorsing this extension. If we lose their support, we may not have broad congressional support to extend the program. So my thoughts are it's better to extend it and work with the service in looking at these target flows and saying, do you really need this kind of a target flow? Do you really need short duration high flows? All of the things that were kind of the best available science in the 1990s to really kind of show and disprove those. And we've been able to do that on a number of other fronts on this program. We've now been able to show that if you want more least or more terns and plovers, which do nest on islands in the Platte River, you're better off to acquire sand pits and let them nest on sand pits, because we build an island on the river, the water comes up, it washes the island away. We have existing islands, they nest in May, high water comes in June, it washes all the nests away. So the service has agreed in that case that, okay, let's move away from islands in the river to these sand pits. So we're making progress, but it's slow. But in the meantime, what this program does is it provides the ESA coverage for water use in Wyoming. And that's why I think the extension is the best way to go. And it'll have broad support as it's currently structured. But if we try to reduce that cap, we'll start to lose, I think, broad congressional support in that. And that's at least my opinion.
Mr. Chairman, I agree. I think we've got some major concessions out of the Fish and Wildlife Service right now. In reality, to the fact that they're starting to understand that habitat's better developed with scrapers and sand pits than water. And we've got enough science behind. We need to finish the science so we could be in a situation, should they go back to the 417, we can say that's not what the science says. So being at the table to prepare the evaluations is a key component of this, and the fact that they're down to 120, 130 is a major concession right now. And I guess I understand your concern, but I don't think right now is the time to rock that boat.
Mr. Chairman, given the history, because sometimes you need to do things when the politics are right in Washington, D.C. And history has taught us over and over again, the science changes with administration there is in Washington, D.C. That being said, you're probably right on the terns, but I just wonder on the pallid sturgeon where it's all water.
Thus far, it's not demanding more water, but that's part of being at the table. We can say, no, the pallid sturgeon is not going to get more water. The program was designed to do no harm to pallid sturgeon. So, but those discussions are ongoing as well. And so I think being at the table is the best place to be. And with the House changing, obviously, in Washington, D.C., it's going to have the support of environmental groups. Yep, exactly. So, Mr. Chairman, that's my report on the Platte River program.
Okay, number 7, number 1 and number 2 project applications.
So March 1 was the deadline for new planning projects. Barry Lawrence has put this spreadsheet together that lists all of the new applications. And we have tentatively assigned commissioner assignments for the projects in terms of them going forward to ultimately reviewing proposals and going to interviews. So, and we'll provide this copy to the commissioners online or other commissioners. So I think the important thing that we wanted to do today was just give you a list of all of the applications you received. So you see level 1 new development, a number of projects, 9. Level 2 new developments, 2 projects, and then level 2 rehab, we have 2 projects there. So those will be your planning projects going forward to ultimately the 2020 legislative session. Senator Hicks, I didn't give you a copy, but if you're interested.
Thank you.
There's no action required today, other than if you happen to see that you might have a conflict of interest with any of these assignments, to let Barry and Lawrence know. And at your May meeting, you will be asked formally to determine which of these projects will go forward through then qualification statements, shortlisting, proposals, and interviews, which will start really after the May meeting and run until the October meeting, where you will then conduct interviews. And those selected firms then determine what the cost of that project is through their cost proposal. And that's what then leads to the November meeting and developing the overall budget for the program. Questions there?
Chairman? Director, could you maybe read those out loud for commission assignments for those on the phone? I don't have those.
Well, I think the best thing would be is we will transmit. There's no decision that has to be made. And so we'll go ahead and get those forwarded to all commissioners, and then no decisions required until May. So, but this is just, we want to let you know, really, here's the projects that came in on your March 1 application deadline.
Take care of that one.
It does, Mr. Chairman.
I have no conflicts.
Okay, number 8.
So, Mr. Chairman, as part of the acquisition of Healy Reservoir and the 3 water right permits in Lake DeSmet, the cost sharing of operation and maintenance in Lake DeSmet, Johnson County owns the reservoir. We own 3 permits that total about 62,000 acre feet of water. And as part of our acquisition, we assumed an old cost-sharing agreement between Texaco and other parties in terms of these 3 permits and who pays for what. And then Sasol assumed that, and we assumed that as well. And in my conversations with Johnson County commissioners last year, I said, and they agreed, it's probably appropriate that rather than operating on this old Texaco agreement, that we in fact put a new agreement in place between Johnson County and the Water Development Commission. So I have drafted the first round of that agreement, and I have sent it on to Johnson County. I did that several weeks ago. I have not heard back from Johnson County. I would expect that as time goes on, there will be new drafts from their county attorney, from them, and review of the Attorney General's office on our part. So at some point in the future, you may see approval of a Johnson County agreement for cost sharing of operations costs on Lake DeSmet. So just know that it's out there and it's going forward.
Question on that one? Okay. You have one, Bill?
No.
Then we're down to the last, number 10.
Number 10, if you go to tab O in your notebooks, you see a listing of all of the places we've been on our summer tours. Last year was Gillette, a year before Green River, Saratoga in 2016, and then Worland before that. So we need a little direction on where you might want to go this summer. And looking at, we have scheduled that meeting for August 14, 15, and 16. My thoughts to you that we might look at the northwest part of the state, whether that's Pinedale. We were in Pinedale last year for a joint ag meeting and a commission meeting, but we've really not been into the northwest part of the state. We have a New Fork Reservoir proposal.
As long as we don't have to go down to the government bridge again.
You don't want to go to Government Bridge.
Never.
You were here when that one went up.
Okay. We got lights on my fanny over that one.
Yeah.
Um,
Well, we want to stay away from
where
government.
are we spending the most money, Harry?
Well, Bighorn Basin, we got a couple of reservoir projects that are on the order of 70, $80 million. We have Big Sandy project, which is where we were 2 years ago. We did view the Big Sandy project. But we've got other reservoirs. The New Fork Reservoir in particular is up in Pinedale country. That's why I mentioned that one. Pinedale has been having some issues with their water supply system at Fremont Lake. And in fact, they've started a working group. It appears that EPA is going to issue an administrative order. So that could be another likely place to look. And there may be ultimately a request for a planning study from Pinedale, but we don't have that as part of the current application package. So
We don't have another bunch meeting there at the same time, do we?
that would be something, once we pick a location, then we would start to look at conflicts.
I'm seeing a Pinedale water supply.
Did I miss that one?
Yeah.
I did. We do have an application for them. So that would be a good opportunity to look into that.
You have a golf course?
Well, imagine.
Here we go.
You got
I'm in.
snowshoes?
And other commissioners on the phone, if you want to speak up and talk about where you might want to go, this would be a time to do that.
I support the Northwest. This is Kellen.
Mr. Chairman, just a quick question. Where are we at with the Grable Valley Irrigation District and the Sunshine Reservoir and all of that?
Mr. Chairman, Senator, we have an item on the agenda tomorrow for a contract amendment that Jason's going to talk about, but you can talk about where we're at on.
Mr. Chairman, Senator Hicks, we've got an amendment for some additional supplemental geotechnical investigation for the right abutment to look at the seepage and what's going to be, I guess, required to handle that seepage as far as grouting and filter material and all that stuff. So we're expecting to get that completed here this summer, have a final report out this fall. Depending on what that says, we're either a go or we aren't, because it has pretty major impacts on cost and economics. So if it looks like it's still a go, we'll move forward and probably ask the next legislative session for permitting and design dollars. But it's about a 20,000 acre foot enlargement of Lower Sunshine.
Upper or lower Sunshine?
Lower.
Mr. Chairman, and would it be feasible to do the Grable Valley and the Levitt Reservoir on the same tour?
Mr. Chairman, the only thing I would say about the Bighorns and Levitt and Alkali Creek, we were just up there in 2015 talking about the same things. And all we've been doing since then is going through NEPA. And we're trying to finalize that and then get started on final design. So it would be pretty repetitive from just pretty recent.
Repetitive for those that were there. But I think both the commission and there's been some change over in the commission, not necessarily the staff, but just a suggestion that would be another alternative.
So, Mr. Chairman, let me suggest this. I want to give that some thought over the evening, and then by tomorrow, end of tomorrow, if you want to decide where you might want to go, do that.
I'll go wherever the bosses say we're going.
Okay. I do think it's important that we make a decision now so that Katie can start the planning, motel rooms and all of that takes place. So, but we could probably wait till tomorrow if you want to.
One place we really got great service one night, and the next one we sat an hour and a half. We finally had to ask them if they forgot about us.
All I got for today, Mr. Chairman.
Any other things you want to bring up, or if not, then we adjourn. We're not going to run around very far to say where we're going to eat. I think we're just going to stay right at the Little America.
Well, we got a party tonight.
Oh.
We got a retirement party